name, stand up, right? Because that's one of the things they look for. Well, did they say the name of the defense attorney? You know, there's nothing I hate more than, and this usually, it's in different perspectives, but on appellate world, when they say, well, Mrs. Wood said, well, okay, it's Mrs. Maselli Wood. We'll start there, and then we'll finish. But, so let's say you make the objection and the judge says, that'll be sustained. Are you done? What do you got to do? Ask for limiting instruction. I like that, stricken from the record. Okay, strike that, jury, pretend you never heard it. Then mistrial. You have to bring your objections to a negative conclusion where you lose. Okay? If you don't do that, you lost. All right, there's some case law in here. Some commitment is good. I'm going to skip through that. Judicial bias. Have you ever had a judge that you thought seemed biased against you? You know, what do you do about that? Well, Judge, I object. In fact, I've kept tally, and you have sustained every single one of the state's objections, and you've denied every single one of mine, and I would like to put that on the record. And you're violating my client's right to an impartial judge and due process and a fair trial. There's a lawyer in Tyler called, what's his name? Wes Volberding. And he did one of those, for those of you who have time and you're bored, there's a great article in Texas Monthly about the Mineola Swingers Club, which was a big case up there, and whether these kids were made to imagine that they had been pole dancers at 5 years old. But anyway, he actually was able to establish that the judge had a whole different set of evidence rules for the state than for the defense. And it was a many weeks long trial. But if you sense something like that, you want to object. Timely, specific, get a ruling. And I hear all the time, I don't like to object because I don't want the judge to get mad at me. Oh, he already is. Or I don't want the judge to not like me. He doesn't like you. If you think he likes you, you're doing something wrong. Yes?
You have a First Amendment right to a fair and impartial judge also.
Thank you. More arrows for our quiver, right? We got the whole bouquet, like Casey said. The more you put out there, the more specific you are, the better you will be, the better your client will be, the better lawyer you will be. All right, I want you to think about this. Batson and J.E.B. I love a Batson challenge. Isn't that awesomely fun? You're like, you have a different idea of fun. Well, okay, that's true too. But I want you to take it further. So Batson is you can't deny a juror because of race. J.E.B. is because of sex. I want you to think about the current climate we live in. Religion. Ethnicity. So far, the courts have said it's fine to dismiss someone because of their religion. But I think we live in a different world than when that case came out 22 years ago. And that's the other thing. If you don't make that type of objection, it's always going to be okay. As the great jurist Larry Myers once said, before Atkins, where they said, you know, you can't execute the people with intellectual disabilities, there was no Atkins. So if you didn't raise it, because that was the law, hey, it's okay to execute these people. If people didn't continually raise it, it'd still be okay. So it's up to you, all of you, to push this. Make it something. If you see on your jury maybe some certain minorities or a different religion represented, make sure you know that they're not being struck because of that. Because not only are you protecting your client, you're protecting all of us to equally serve on a jury. All right. Juror withholding information. Describe to the trial court what questions you would ask the juror to establish misconduct or bias. Again, it's all in the information you put on the record. It's probably not going to make that big a difference in your trial. And so you're thinking, And I hear this a lot too, well, I'm a fact lawyer. Oh, that's great. But when we get to the Court of Appeals, the facts don't matter. The law does. So help us. All right, final thoughts, because I want you to be able to see some of the Astros. All right, I have rarely seen someone object too much. I've never seen it. Yeah, it's like the unicorn. Well, I don't want to object too much. You're not. Put on the record what's harming you. It's okay to use civil cases for evidentiary issues. Have an objection written out. You know what you know what they're going to try and do. I tried a case before Judge Guinea, and I knew they were going to try and get in all my clients' prison cases. And so I was just ready for it. And I had all these cases highlighted. And the DA was like, well, all this is coming in. I'm like, no, it's not. Violates due process. And so we ended up, they redacted a bunch of stuff, but I still objected. But I knew what they were going to do. You've read the offerance report. You know what they're trying to get in. You know what they don't want in. So rarely should you be surprised by this. All right. Like I said, like with Skip's case, I will appeal a case for years and years and years. I enjoy that. I like to play every day. When the DA gets my brief, I want him to feel like he's eating glass. Yes. Yes, that is true. And it's about staying in the game. For those who are baseball fans, who are these two people? Cal Ripken and Lou Gehrig, what are they famous for? Longevity. Longevity. They played every day, day in and day out. And that's what we're going to do, right? All right, go Astros. Thank you.
On the left something.